Good afternoon, everyone. Welcome to today's edition of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano. I'm an employment lawyer, an associate with Samfiru, Tumarkin. I work out of the Toronto office. So if you guys have any questions related to your employment and your rights as an employee, feel free to send them to us. Get a hold of us through multiple ways, Facebook, LinkedIn, Twitter, YouTube. You can also go to employmentlawyer.ca. Email us at help@employmentlawyer.ca or call us at 1-855-821-5900. I'd like to start today by talking about the recent vote from the Ontario English Catholic School Teachers Association, which they announced that their members voted 97% in favor of a strike. So when a school strike happens, parents have to stay at home to take care of their kids, right? There's child care obligations. In situations like that, those parents either can't work at all or need to be able to work from home. So what are a parents' rights in a situation like that? Well, the Ontario Human Rights Code, which applies to all provincially regulated employees in Ontario, protects employees and their rights on a number of grounds. Most notable and most commonly talked about are disability, race, religion, but it also protects on the grounds of family status. And family status has been interpreted to encompass child care obligations. So in a case where your child's school, the teachers have gone on strike, they can no longer go to school during the day. You therefore have the right under the Human Rights Code to ask for accommodation. That accommodation can take multiple different forms. One form could be needing to be off work, so being on an unpaid leave of absence. If that's what you require because your child needs full-time attention, then you have that right. And then when your child does go back to school, your employer would have the right to return you. If the company can't support it, then you can also ask to work from home. The only way the company would be able to say no is if allowing you to work from home would create undue hardship on the company. Now, undue hardship is an incredibly high bar to pass, especially in a situation if you previously worked from home during the pandemic and the company built up that infrastructure to support it. If the company didn't allow you to work from home to take care of your kids, they'd be hard pressed to establish undue hardship. If a company refuses to accommodate you, whether by allowing you to work from home or allowing you to take an unpaid leave of absence, then in that case, they're breaching the Ontario Human Rights Code. When a company breaches the Ontario Human Rights Code, you have a number of options, and the best one is always a case-by-case analysis. But one of those options can be pursuing a claim for constructive dismissal and pursuing a full severance claim. Severance claims and how much an employee is entitled to depends on a number of things: age, length of employment, availability of similar employment. But it can be as much as 24 months. So if you're in a situation where your child's school, the teachers at your child's school do strike, you have to take care of them and your employer refuses to accommodate you or says, we don't care, you have to still come into work, business as usual, then give us a call, 1-855-821-5900. One of our experienced lawyers will be able to help you out and advise on your rights. Frank P. from YouTube, he says, as the president, the highest ranking executive in Canada, with my employer's owners based in the United States, should I give notice when requesting medically advised stress leave, particularly in the absence of immediate replacement? Are there any legal implications? Well, it obviously depends on the situation, right? So if you're in the situation where your doctor has said you need to take a stress leave, you need to take it right now, and it's for your health, you don't have to give them notice. Now, it always gets tricky when dealing with companies based in the United States. Ontario and Canadian employment laws are much, much, much more employee friendly than the laws in the United States. So while you don't have to give notice, if it is at all possible to give them notice, it's not necessarily a bad idea. But make sure you have the necessary documentation, meaning a doctor's note, physician's note from a psychiatrist, something along those lines that proves that it's medically necessary. And then also try to do everything in writing. In situations like yours, Frank, things can often, unfortunately, deteriorate, and end poorly. And the last thing you want is a he said, she said. So if you can give them notice, do, but you don't have to, and communicate in writing is probably the best thing you can do. Samuel says, can an employer refuse to bring you back after parental leave? They are saying there's no position available at this time. Sammy, no, they can't. So refusing to bring you back after parental leave is a violation of both the Employment Standards Act and the Human Rights Code. So under the Employment Standards Act, a parental leave is considered a leave, and there's a specific section, I can't remember exactly what the number is, but it states that when a leave is over and the employee is ready to return, the employer must return them to the same position if it exists, or if it doesn't, a comparable one. So what we often see happen is, especially in smaller companies, somebody will go on a parental leave. The company will hire a short-term replacement, a year, 6 months, 9 months. And then when the person on the parental leave is ready to come back, the company says, well, we've replaced you. We don't have a position. We can't just hire everybody. They're not allowed to do that, point blank. They have the obligation to return you to work. And additionally, because them refusing to return you to work is directly related to your family status, meaning being a new parent, then they've also breached the Ontario Human Rights Code. So they're refusing to bring you back. They've breached the law. They've broken the law. So in your case, Sammy, it would be best to give us a call or reach out to us at employmentlawyer.ca, and one of our lawyers will be able to help you out. You'll likely, but not always, but oftentimes be able to pursue a constructive dismissal claim and pursue severance. Mr. Kittles from YouTube asks, are construction workers entitled to severance pay and notice of termination? So this is where it gets tricky. Construction workers are their own special class under the Employment Standards Act. So under the Employment Standards Act, no, they aren't. Construction workers are deemed not to be entitled to statutory termination pay or severance pay. With that said, they are entitled to common law severance pay and a common law severance package. So even if you are a construction worker and you are let go, you're still entitled to pay in lieu of notice of termination, severance pay, notice of termination. But it's just a little trickier to get it. So if you're a construction worker who's been laid off and terminated, give us a call, and one of our lawyers will be able to help you out. It isn't the situation where construction workers can be let go and they're entitled to nothing, although that's oftentimes what construction companies make it seem. Liz McGee from YouTube asks, BC worker here, being off on leave, doctor's note in hand saying accommodation is necessary for me to return. How long do I wait for a response? So far silent. So Liz, I work in the Ontario office, and the employment law in Ontario is a little different than employment law in BC. So I think it'd be best to check in at one of our future employment law Q&As with one of our BC lawyers. I know they're hosts on a regular basis, but generally speaking, you do have to provide them a reasonable amount of time in order to respond, right? So the company would have a duty to accommodate, meaning they would have to look and make inquiries as to whether or not they could accommodate you in your current role, or if not in your current role, is there another position they could put you in? An example of that would be maybe you work in a warehouse and you're building boxes and mailing things out all day, but you hurt your shoulder, so you can't do that anymore. Well, they can't accommodate you in that role, but they can make you an accounts payable clerk at the same rate of pay. So the company does have a duty to inquire and investigate to see if they can accommodate you, or if there's another position you could fill. So if it's been 24, 48 hours, that's okay. If it's been longer than a week, it's just following up. They don't get to sit on their hands forever, but they are allowed some time to make the necessary inquiries to ascertain whether or not they actually can accommodate you in your position. But again, that's the law in Ontario. The law may be different in BC. So check in at one of our future shows with one of our BC lawyers, and they'll be able to answer and help you out. So we've got a question from Danny on Reddit. My employer is holding me responsible for property damage because I was working when someone came into our restaurant and threw equipment around while I was trying to call for help. They have suspended me and are withholding pay. I'm not sure what to do. So the point blank, you're not responsible for that. It wasn't damage you caused. It wasn't anything you could have done to stop it. You were seeking help. You were actively trying to ameliorate the situation. So if they have suspended you without pay and are withholding your pay, they're breaching the law. They're breaching the Employment Standards Act. They're breaching the common law. And you absolutely have the right to pursue a termination claim against your employer and pursue full severance. It's unfair. It's patently unfair for an employer to hold you responsible for the acts of someone else in their workplace, right? It was the employer's job to keep you safe, and by the sounds of things, they failed to do that as well. So your employer's in the wrong. They don't have the right to withhold pay. They can't suspend you without pay, and they can't ask you to pay for the property damage caused by someone who entered the restaurant. So based on that, Danny, I think it'd be best if you gave us a call, reached out to us at employmentlawyer.ca. One of our lawyers will be able to help you out. Your employer's absolutely in the wrong on this one, and you're entitled to the money you've earned. They are not entitled to be reimbursed for the property damage, and you're likely entitled to a severance package as well. Question from Tanya on YouTube. She asked, can an employer let you go for making a mistake that other employees have not been fired or reprimanded for? No, they can't. So under the Employment Standards Act, the term just cause doesn't exist. And instead, the legislation uses the phrase, the term, willful misconduct or neglect of duty that is not trivial or condoned by the employer. And it's that last part, that condoned by the employer, that matters in this case. So if there's a mistake, maybe it's miscounting the till, you're off by $5-6. Maybe it's dropping a glass when you work at a restaurant. A mistake like that, if it's happened in the past and the employer has let it slide, by letting it slide, by not reprimanding others, they are condoning that behavior. So if the employer then chooses to say, no, well, Tanya, everyone else has miscounted their till by $5-6 here and there. This is the first time you've done it. It's unacceptable. You're fired. They're clearly arbitrarily enforcing the rules of their workplace. And then they can't let you go without paying you anything. One of the things in Ontario for provincially regulated employees is that employers always have the right to let go, terminate an employee's employment. They just can't do it without giving them proper notice or severance. So if you have been let go for making a mistake, there's likely nothing we would be able to do to get your job back. However, we would be able to pursue a severance claim on your behalf. And how much severance you'd be entitled to, of course, depends on your age, how long you're with the company, and the availability of similar employment. So follow up, Sammy asked, can they make her take a lower position instead? She was a previous manager. So I believe, so Sammy says his sister's dealing with this. I believe Sammy's referring to the returning from parental leave. So they cannot make her return to a lower position instead. So they can't make her return to being a non-manager when she returns from parental leave. They cannot make her accept a lower rate of pay. Again, what the Employment Standards Act says is it's the same position if it exists or a comparable one. So if that same position exists and they just merely put someone else in it, then they have to place her in that role by law. They can't, and they also can't make her accept what would be a functional demotion and returning to the workplace. Our courts have said that not only are demotions damaging because they pay less money, right? If you go from a manager to a non-manager, you typically earn less money. Not only is there less prestige, but it also is embarrassing to the employee. And our courts have consistently and routinely affirmed the principle that you are not expected to work in an atmosphere of hostility and embarrassment. So which is the atmosphere that your sister would likely be in it if she returned to work. So no, they can't make her return to a lower position. They can't take away her management titles or responsibilities, nor can they reduce her rate of pay. Question from BY Close on Reddit. I hurt my back on the job and need to take a few days off. Now my employer won't respond to my calls or texts, and I think they're trying to let me go. What should I do? Well, so most important thing, BY, is to paper everything, right? So while calls are great and they're oftentimes the easiest way to get a hold of people, it is oftentimes best to send everything in writing. Text messages are fine. Emails are typically the best. Sending things in writing ensures that there's a paper trail. You got hurt. You had to take the time off. I'm not sure if you filed a claim with the WSIB. If you haven't, I would suggest exploring that option. The WSIB does protect employees who are hurt on the job, and they also ensure that employees are returned to work when they're supposed to be returned. So paper everything, text your boss rather than call them, email them. And if they stop responding to you, never call you back, don't give you shifts, then you've been terminated and you can pursue a severance claim. You can also likely pursue additional damages for breaches of the Human Rights Code, because by the sounds of things, they would have breached it and choose to terminate you after you got hurt. So, first thing is look in the WSIB, and then if they are refusing to bring you back, then reach out to us at employmentlawyer.ca and we'll be able to help you out. Brennan on YouTube asks, says his employer is claiming negligence and placing on a PIP, so performance improvement plan. What can I do if the reasons for this are false? Will they be able to let me go without pay? So whenever an employer wants to terminate an employee for performance-related cause, meaning they haven't met the performance expectations of the employer, the first step in that process is placing the employee on a performance improvement plan. Now, that performance improvement plan can't be very short-term. It needs to set meaningful, achievable targets for the employee to reach, and then the employer also has to try and coach them up to help them reach those targets. So, Brendan, if your employer is claiming negligence, I think the best thing to do in your case, I kind of sound like a broken record today, but is to paper it, right? So if you think the reasons are false, if you think they're unfair, send an email. Send an email to your boss, send an email to HR, send an email to the person putting you on this performance improvement plan so that it's in writing. Also, take a look at the expectations, take a look at the objectives. If they make sure they're tangible, meaning they are things that can be boiled down to brass tacks, to numbers, not something that is subjective, right? So a subjective performance might be develop better relationships with colleagues. That's something that is so hard to quantify that to have it in a performance improvement plan is unfair to the employee. So make sure that everything in that plan is tangible, that it can be measured. Make sure that if anything is unfair or unachievable, you articulate it to the employer. And if you're not guilty of negligence and you didn't do anything wrong, then put that in the email as well. If all of that notwithstanding, your employer keeps you on the PIP and then tries to let you go without pay and say that they're terminating you for just cause, give us a call. Just cause in all cases, but especially in performance-related cases, is incredibly hard to justify. And just cause is one of those things that is binary. So it's either there or it's not. So if the company did not have cause, then you're entitled to a full settlement package, which, depending on the circumstances of your employment, can be worth as much as 24 months pay. Natalia from YouTube says, my employer sent me on a temporary layoff. They told me I have the right to claim EI. Am I allowed to leave Canada for vacation and still receive the EI benefit while I'm abroad? So I don't deal too much with EI, but generally, in order to receive employment insurance, you need to be actively looking for work and in Canada. I think you can leave on weekends, but I don't think you can go abroad for weeks at a time. That being said, if your employer has put you on a temporary layoff and it's the first time in your employment, you do have the right to pursue a constructive dismissal claim. So especially during COVID, there was this common misconception that employers could temporarily lay off or furlough employees temporarily and then just bring them back whenever they wanted. That's not the case. So under the law, if it's the first time an employer has laid you off and in your employment contract, it does not explicitly say that the employer is allowed to lay you off, then you're entitled to pursue constructive dismissal and a full severance claim the first time it happens. The only tricky thing there is you can't accept it. So you have to pursue that pretty quickly after that first layoff. And then if that layoff is to last longer than 13 weeks or 35 weeks and they continue your employee health benefits, then that layoff automatically turns into a termination and you're entitled to severance at that point. So if you've been temporarily laid off, it's the first time, it doesn't say that the company can in your contract, or you don't have a contract at all and you want to pursue a severance claim, so you want to leave that employment, give us a call at 1-855-821-5900, or go to our website at employmentlawyer.ca, and one of our lawyers will be able to speak to you and really give you an idea of what your full rights are in your situation, Natalia. TechMX asks, do human rights expire for legal action on a time frame? So your human rights under the Human Rights Code exist, right? And there's no time expiry on you having those human rights. That law was passed, I believe, in the 90s and is still enforced today. I think what you're referring to is if someone violates your rights, so you're discriminated against contrary to the code, is there a time frame for you starting legal action? So generally in Ontario, there's a 2-year limitation period, meaning from the date on which you knew that you had been discriminated against, you have 2 years to start a lawsuit. So an example would be if you found out that someone discriminated against you contrary to the code today on October 20th, 2023, you then have until October 20th, 2025 to start a lawsuit. So it's quite a long time. It is 2 years, but there are situations where people run into things. So if you feel like you have been discriminated against at work, it's best not to sit on your hands. Give us a call, reach out to us at employmentlawyer.ca, and we'll be able to help you out. And TechMX, if that's not the question you're asking for, feel free to comment again and clarify. But yes, you have 2 years to start a claim after someone's discriminated against you, and that applies to everything. So you have 2 years from the date on which you're terminated to start a severance claim. You have 2 years from the date on which you were laid off to start a constructive dismissal claim. We've got an email question from Reginald. My employer let me go for cause a few months ago. I was hoping to pursue a severance claim with a lawyer, but have since found a new job. Should I still go after my previous employer? Yes. So you should absolutely go. You should absolutely still contact us. There is an offset when someone finds a new job with severance pay, but there are also some amounts that can't be offset. So if it's a case where you worked for this company for a long time, there was a big company, then you can go after your employer for your amounts under the Employment Standards Act, which aren't subject to mitigation, aren't subject to any offset, and you can still pursue it that way. So give one of our lawyers a call, get in contact with us, and we'll be able to tell you if it makes sense. Also, how long you were without work matters too. There's a bunch of things to consider, Reginald, and until we see the full picture, it's difficult to say whether it makes sense to go after your previous employer, but generally it is. TechMX, just before I realized I missed something on my last answer there. The 2-year limitation I spoke about was for lawsuits. Under the Human Rights Code, you can pursue an action with the Human Rights Tribunal of Ontario, the HRTO, and they have a 1-year limitation period. So 1 year if you want to pursue it through the HRTO, 2 years if it's just a general employment law claim with a disability discrimination aspect, excuse me. I have a wrongful termination claim, Moniar on YouTube asks. What is the best way to state a claim when filing your case against an employer who has terminated your employment, who's now seeking to have the case dismissed? So Moni, what you're talking about is legal writing, right? So, in a statement of claim, in a lawsuit, you have to articulate a cause of action. You have to plead damages. It's a highly technical endeavor, right? So that's why I went to law school. That's why I'm a lawyer. So if you have a wrongful termination claim, it's best to reach out to us, and one of our lawyers will be able to help you out. If you're trying to do this on your own, it's really difficult for me to articulate what a proper claim would be, how to properly articulate a cause of action. So if another lawyer is trying to have your case dismissed for whatever reason, and you're pursuing this on your own, then it's probably best to reach out to us, and one of our lawyers will be able to help you out and hopefully keep your case alive and keep it going. So we have an email question from Neil. Does starting up a business as a competitor with your current employer leave you liable to anything? There's no formal contract or any form of non-compete. So Neil, your situation's difficult. So if you're going to be actively employed with one company and then open up a second company that actively competes with it, you're in a very precarious situation, I think is the best way to put it. So while there may be nothing against it in contracts saying you can't compete, there are other duties that exist that an employee has to the employer depending on where they are in the company. Depending on whether your management or your position in the company, you may have a fiduciary relationship with the employer, meaning you have to look out for the employer's best interest. You have ongoing duties of confidentiality, meaning you have a duty to keep all the company's information, their trade secrets confidential. And you also have a duty to work for the company during work hours while you're getting paid. And if you're in management, right, and you're therefore not entitled to overtime, that water gets even murkier. So while there may be nothing on paper outlining it, it is a precarious situation, something that I would aim to avoid. If that is what you decide to do and something does happen where your employer either lets you go or tries to pursue legal action against you for whatever reason, then give us a call. We may be able to help you out, but generally, Neil, I think that's a situation to avoid. So we're coming up on our half hour here, so I'll answer one or two more questions and then we'll wrap up for today. So I've got a question from JM on YouTube. He asks, can an employer let you go for your activity on social media? So it depends on what that activity is, what's being said, and when it's being said. So if you are on social media tweeting, Facebooking, posting on Instagram during work hours, spending a lot of time on social media at work, your boss finds out, is able to prove it, and then gives you multiple warnings and you still don't change your behavior, then there's a possibility that they can let you go for that. Now, if it's instead something that, if it's instead a situation where you've just posted something, maybe it's a political opinion, maybe it's a position on another issue that they disagree with and they choose to let you go for it, no, they can't let you go for that. As I mentioned earlier, employers in Ontario do always have the right to let someone go. They just have to pay them an appropriate amount of severance. So in your case, JM, if you said something or posted something on social media your employer disagreed with and they let you go because of it, we might not necessarily be able to get you your job back, but we could pursue a severance claim on your behalf and make sure you're paid. You're paid appropriately. All right. So our last question of the day will be from Michelle on Facebook. Can my employer make me take a work from home position permanently? So it depends on the circumstances of your employment. If it's a new job and you're newly to this company and they're only offering you a work from home position, then yes, they can make that decision. If it's a situation where pre-COVID you worked full-time from home or full-time in the office, you started working from home during COVID to help the business survive the pandemic, and then now the company wants to make you work from home permanently, the likely answer is no. Whenever an employer makes a unilateral change to the terms of someone's employment, a substantial unilateral change to the terms of an employee's employment, the employee has the right to pursue a constructive dismissal claim. And in your case, unilaterally imposing a work from home situation would likely be considered a unilateral and substantial change. So that's it for today, everyone. Thank you for joining us. Again, my name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru, Tumarkin, LLP. And this was today's iteration of the Employment Law Q&A. Our next one will be with Luke Serta on Monday, October 23rd at 1 p.m. Mountain Time. He's a senior associate with our Calgary office. Thank you for joining. I hope you all have a great rest of your day.